In this docket, State of Kansas versus Jason Carl Herbster. It is case number 2023 CR 221. Chris Pate appears for Richard Pa as defense counsel. Amber Norris appears for the state of Kansas. Jason Herbster appears at the court security Zoom location at the Judicial Center. This matter comes before the court at this time for further hearing on allegations of alleged probation violation. Those allegations are not currently before this court. Ms. Norris, what are the current alleged violations against Mr. Herbster?
Your Honor, the warrant, it looks like, was, well, he was arrested on August 19th. The allegations are that he pled no contest to possession of marijuana in Jackson County District Court. That's a conviction on May 5th for an offense on January 9th. And then on June 6th, the defendant submitted a UA that was positive for THC and admitted usage. And on June 19th, admitted consuming marijuana. On July 15th, submitted a urine sample and it was positive for THC, and the defendant did admit use thereafter.
Very well, thank you. Mr. Pate, what are your client's intentions regarding these allegations?
Your Honor, he's going to waive hearing. He admits number 2 is true. He admits number 1 is true. However, I would like to note the date of offense on that was January 9th, 2025. Mr. Herbster had a previous show cause hearing on April 4th where he was reinstated with a sanction. So I am noting for the record, while he did in fact get a conviction for marijuana, the offense occurred before the last show cause hearing.
So noted, Mr. Pate. Mr. Herbster, your attorney has indicated that you would waive any formal due process hearing you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You do have the right to such a hearing with the assistance of your lawyer. You could present your own evidence, challenge the state's evidence, confront the state's witnesses unless good cause was shown. And I need to point out to you that among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your 11-month DOC sentence locked up. Do you understand these things?
Yes, I do.
Jason Herbster, do you waive a hearing in this case and stipulate and agree that you committed these violations?
Yes, I will.
Very well. Court finds that the defendant has knowingly waived his right to a hearing and stipulates and agrees that he committed the violations as alleged. The court also notes Mr. Pate's explanation regarding the timing of the no contest plea to possession of marijuana and when the offense occurred date really was, which was prior to his last show cause hearing. With that noted, at this point, the court will ask for recommendations regarding appropriate disposition. I will begin with Amber Norris on behalf of the state of Kansas. Amber?
Thank you, Your Honor. Your Honor, this is defendant's second warrant to show cause. The court had previously given defendant 3 days in the county jail as a sanction on that previous warrant, which had to do with failing to abstain from using illegal drugs and having dirty UAs. And then also he wasn't completing or participating in treatment. So some similar allegations between the first show cause and this show cause. This is SB 123 case, so the treatment and the lack of drug alcohol use are key issues on this defendant's probation. Your Honor, he was initially placed on probation on March 25th of 2024. And that was for up to 18 months. I do believe that he would need an extension of 12 months community corrections probation with all previous and standard conditions to include that he complete treatment and stay drug and alcohol free. But Your Honor, based on the violation, state would be requesting 3 days in the county jail, and then that the court also address additional attorney's fees and bids application fee as counsel, I believe, is appointed.
Thank you, Ms. Norris. Mr. Ketley, do you have any independent recommendations or information for the court?
I do not, Your Honor.
All right. Mr. Pate, your recommendations regarding an appropriate disposition?
Your Honor, I think a 2 or 3 day sanction is appropriate. While it's certainly not good that Mr. Herbster pled no contest to a new case, that occurred before the last PV hearing. So the only new and independent violations since he was last before the court are the positive tests. Mr. Herbster informs me that he has completed inpatient. He did successfully complete outpatient in September. And I would note the PV before this, part of the allegation there was that he was unsuccessfully discharged from treatment. So according to him, he's re-engaged and completed, which is encouraging. I don't think this is a case where there's obviously willful non-compliance with treatment or intentional conduct where he's trying to avoid the Senate bill treatment. He did on his second try complete that successfully.
Mr. Pate, what about the intentional ingestion of controlled substances that he's been specifically ordered to stay away from?
Well, certainly, Your Honor, we all have choices, and he made a choice to use. It's my hope that if he's engaged in this treatment and complete it, it's going to make it a little easier for him to make correct choices in that regard. And he did make the choice to stick with treatment and complete that, which is encouraging to me. He is employed at Moore Printing Press up near Holton, making $14 an hour. As I said, I think a 2 or 3 day sanction is appropriate. An extension of the court's discretion is appropriate, but I don't think this is a case that at this point warrants outright revocation, Your Honor.
Thank you for your recommendations, Mr. Pate. Mr. Herbster, it appears that the court's choices are this. You go to jail for 3 days, you go to jail for 60 days, or you go to prison for 11 months. What's the right choice for the court today, Mr. Herbster?
I would say 3 days.
Well, I'm not surprised you would come up with that. Mr. Herbster, I don't understand why you continue to use, even after treatment has supposedly taken in your case, you're still coming up with positive tests. The entire focal point of this case was to get you free of these illegal street drugs. And yet, so far, it's not working. Is there anything else that you would offer in mitigation of punishment here?
Sir, I just got to tell you, if you're looking at somebody who has changed, I have changed. I used to stay up late, go to bed, horrible things. And now my day is I get up at 5 a.m. I go to work at 6:15. I come home, I play ball with my kid, make dinner, and go to bed by sometimes 8 or 9 o'clock. I'm doing my best, and I apologize that I'm not on the same page. But again, 3 days would be great. But again, I'm sorry. Sorry to take up all your time, really.
Mr. Herbster, I know you struggled with addiction. You've relapsed. There are implications to someone who's on felony probation relapsing, even though they're giving in to their addiction. This court will impose a 3-day dip sanction on Mr. Herbster, then reinstate his community corrections, extend that community corrections period to September 25 of 2026. I hope you get done early, Mr. Herbster, and I'm sure Mr. Ketley does too. But you need to show that you don't use anymore and that you complete all your other probation requirements. Any unsatisfied condition of your community corrections probation remains. You'll be released in 72 hours back onto community corrections, Mr. Herbster. And I hope what you told the court today is true, that you've basically evolved to a new life that doesn't involve drugs anymore. And I'm really pleased that you have a good job up there that gets you out of bed every day and gets you going. I think that's a very positive thing, and that's heavily influenced the court's decision today, Mr. Herbster. Good luck with that.
Thank you.
All right, I am ordering you into custody, though, at this time to serve 72 consecutive hours, 3 days as a dip sanction, and then be reinstated on community corrections. Mr. Ketley, before he goes, what direction do you give him?
Jason, just stay in contact with the ISO up there where you're at already.
Okay.
Okay. Thank you, Mr. Ketley. If there's nothing further, the court does not intend to assess any more fees to Mr. Herbster at this juncture. I'm going to waive any additional fees at this time.
Judge,
Anything else we need to address, Ms. Norris?
Judge, I just wanted to confirm the extension date.
Is to September 25 of 2026. Mr. Pate, anything further?
No, Your Honor. Thank you.
Very well then. The Herbster matter will currently be in recess. We'll move on to another case. Mr. Herbster, you're in custody.
Yeah. Yeah.
All right. Are we actually ready with someone here? Mr. Favre, perhaps?
I'm ready, Your Honor, yes.
And your client?
Mr. King Bayamunga, he is present at custody.
I have two files. State of Kansas versus King Solomon Balamwanga. Its case numbers 2024 CR 59, 24 CR 488. Joseph Favre appears as defense counsel, defendant at the detention facility Zoom location. Amber Norris on behalf of the state. Confident that the defendant faces similar violations on each of these two cases, essentially failing to report for his scheduled office visits with his probation officer, as alleged by Mr. Ketley from Community Corrections. What are your client's intentions, Mr. Favre?
Judge, spoken to Mr. Bayamunga, and at this point, he is going to waive his right to an evidentiary hearing and stipulate to the violations that are on both cases.
All right. I'll inform the defendant that he does have a right to a due process hearing where the state has the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence, present your own evidence, have the assistance of counsel, and confront the state's witnesses unless good cause was shown. And again, among other lesser remedies, the court could consider an outright revocation of probation and the defendant serving the remaining balance of his sentences locked up. You understand these things?
Yes, Your Honor.
And do you waive a hearing in this case? And
Yes, Your
stipulate
Honor.
you agree that you committed these failure to report violations?
Yes, Your Honor.
All right. The defendant has waived a hearing in the case, stipulates and agrees that he committed the failing to report violations applicable to both of his cases currently being supervised by Mr. Ketley. That's a substantial material violation of the terms and conditions of this defendant's probation. I'll also note there have been several prior hearings for violations in this case. So I'm going to be asking for specific recommendations regarding disposition of these two cases, beginning with Amber Norris on behalf of the state.
Thank you, Your Honor. And 24 CR 59, the court is correct. The defendant has had two previous warrants to show cause, both back in 2024, where the court did assign him to a 3-day dip and then also a 60-day sanction in the county jail. Your Honor, the defendant is basically having, I guess, continues to have similar problems. Reporting seems to be an issue. And then he was having issues with going to treatment in a previous show cause. Although in this particular one, the defendant's not reporting. So I suppose probation could assume that he's having issues going to treatment, but would not know that or really anything else because he's not reporting what's going on in his life. So it's difficult for community corrections to assist him in completing all of his probation conditions. because he's not reporting. And Your Honor, like I said, this is the third warrant to show cause in this case. We would be requesting that the court revoke the defendant's probation and then to be ordered to serve the underlying balance, which is 12 months. And Your Honor, in this case, it appears that he is entitled to 158 days of jail time credit. And Your Honor, regarding 24 CR 488, this is actually the first time this case has been on for a warrant to show cause. We would ask that the court revoke the defendant's probation in this case as well. And I know that the court has not done any graduated sanctions with him, but I do believe that the court can revoke based on the offender welfare finding, I believe, is appropriate in this particular case, and that defendant is not reporting, defendant is not abiding by probation. He's clearly has not been doing well at probation since this is the third show cause in one case. And basically after he got out of jail, he was ordered to report and basically didn't, because his failure to appear on probation, it was March 11th. He was not arrested on this warrant until September 2nd. So I have no idea what he has been up to in the interim, but it does not appear that it's to his benefit for the defendant to be on probation and out in the community. He doesn't seem to be able to follow through, and we would ask that the court make the special findings and revoke the defendant's probation in 24 CR 488, the balance of and have him serve the balance of the underlying sentence, which is 9 months in the Department of Corrections. And it appears that he's got approximately 127 days of jail time credit in that case. And I would note for the court that these two cases are required by law to run consecutive and previously been ordered to run consecutive. And the court will need to address additional attorney's fees and bids application fee in each case.
All
Thank
right.
you.
In the 5-9 case, I think you announced 158 days of jail time credit, correct?
Correct, Your Honor.
And the number that would be specifically applicable to 488 would be what?
127.
Your Honor, that is 127 days
All
in
right.
jail.
Mr. Ketley, this case was assigned to community corrections with the idea that you would guide King Solomon through a community corrections program where he wouldn't have to go to prison. What is your perspective here?
Your Honor, I agree with the state. I've had him for probably roughly 17 months, and I've seen him probably 3 or 4 times. He gets out of jail and he just won't report. I mean, he gets out on the streets and things just go bad for him, I believe.
All right, thank you, Mr. Ketley. Now, importantly, Mr. Favre, what is your position on behalf of your client?
So, Your Honor, I think we have a couple of things we have to look at. The first is just that on the second case, the 488 case, we haven't had an intermediate sanction for him. The statute requires graduated sanctions except under certain circumstances. Certainly, Mr. Vayamunga has failed to report. That's accurate, but he has not gone out and committed new offenses to anybody's knowledge, and nor has he done anything else that would show that he's just a danger to himself or others other than not reporting. And I think that's the issue that we're kind of looking at here. Not reporting is certainly serious. I don't want to downplay it, but we have a graduated sanction scheme for a reason. The other case, Mr. Vayamunga definitely has had multiple chances on that case, and he would admit that he has not taken advantage of those cases, those opportunities. I mean, he informs me now that basically that he has gotten out, he's gotten into substances again, and it's all substance driven, and he just fails to report. And he's been living essentially in a homeless state for the entire time he was off. There's a couple things that cut in his favor. He tells me now that he has gotten into some kind of new church, and they have some kind of a rehab program to restore people. And the name of that church is well, he says it's the Apostle Church. I don't know exactly where it is, but it's apparently a new church he got into. Tried to research it, couldn't find it. But I think this is more important, is that he wasn't picked up by officers. He turned himself in. And, it was after quite a while, but the fact that he turned himself in as opposed to being picked up on the streets, I think is an indication that maybe he's ready to start taking some responsibility, which he says he is. So we're asking the court to give him, in the newer case, a 3-day sanction that would fulfill the statutory requirements, and then release him back on probation with an extension, it sounds like. On the older case, we're also asking for another graduated sanction. He's already been in for 30 days this time. If the court would allow that to suffice and allow him to be out after his 3-day dip, then that would be cleaner. But if the court wants to give him another sanction of another extended period of time of 60 days, that would be also, we think, an appropriate remedy. But we want him to be able to get out, take advantage of this program he thinks is going to work for him, and also come back with no blurry legal questions regarding whether we followed the statutory guidance for sanctions. So that's our request. In the alternative, if the court's willing to consider a modified sanction, he's currently looking at 21 months total between the two. We'd ask the court to consider modifying that, at least in recognition of the fact that he turned himself in and took some responsibility there. So those would be our requests at this time.
All right, I appreciate your spirited advocacy on behalf of your client, Mr. Favre, but the whole concept of not revoking him on a second case if he's revoked on the first, I'm not sure how that's congruous with practicality. How could he possibly perform adequately on probation on the newer case if he was serving prison time on the old one?
Well, that's one of the reasons why we asked you not to violate the old one and to give him just an intermediate sanction and return him. Because you're right, there's definitely a conflict there.
This time, the court will address the defendant personally, and I'll ask him if he has any statements that he wishes to make in mitigation of punishment here, or anything further that he would like to present.
I would just like to say that I apologize for letting my addiction get the better of me. You've given me multiple opportunities to try to better myself and show up at probation, and I've kind of just scorned that and ignored it because I've gone straight back to alcohol and drugs, and I turned myself in because I want to do better. I don't want the rest of my life to be living on the streets and getting drunk and getting high and all of that. And if I have to serve prison time, then that's God's will. Like, that's where I'm supposed to be if that's what happens. And other than that, I think that's about it.
Thank you. As has been noted here, this is the third time around that the court has reviewed this defendant's sentence. This court has used a dip sanction on the first occasion, a much longer, in fact, a maximum sanction period of 60 days in jail on the second go-around when he was before this court for revocation on 24 CR 59. That has really had no material effect on the behavior of the defendant, his willingness to stay drug-free, or to even report to his officer on a regular basis. It does appear to this court that the probation on case number 2024 CR 59 has failed. Court wishes to express to the defendant that I really wanted to see you complete this program, but I think you need to be, to a certain extent, protected from yourself as far as drug use and homelessness. The court will revoke the probation of this defendant in case number 24 CR 59. This court will order, in this case, a lesser sentence of 11 months in Department of Corrections custody. Further, I understand Mr. Favre's arguments regarding graduated sanctions in 24 CR 488, but quite frankly, it's wholly impractical for him to be expected to successfully complete probation requirements on a case when he's in prison. And it does appear that for an extended period of months, he's going to be in prison in case number 24 CR 59. It's not in the best interest of this offender to be back out on probation at this point on either one of these cases. He has not shown that he can be successful and drug-free and maintain a healthy residence during the time that he's on probation in this court. The court believes it's in his best interest actually to maybe be in a Department of Corrections facility for longer, where he won't be homeless. He supposedly won't have access to drugs, and perhaps can take advantage of rehabilitative programs within the Department of Corrections. The court will therefore also revoke probation in case number 24 CR 488. I do note that the original sentence imposed was 9 months in the Department of Corrections. This court will modify that sentence to a lesser amount pursuant to statutory authority. Court will lessen that sentence to 7 months. However, that is run consecutively to the time imposed on the 5-9 case. This court also observes that he does have, apparently at this point, over 9 months jail time credit. These sentences are subject to 20% of good time credit. Both would be subject to 12 months of post-release supervision. Bayamwanga, while the courts revoked both of your cases and ordered you to serve consecutive sentence in Department of Corrections custody, you can get out relatively quickly if you're earning your good time credit. I hope that the period of separation from the community is long enough for you to benefit from it, to the extent that your system will be drug-free, and that you might be in a position to be successful when you get out on post-release supervision. And that's really my hope and my goal.
Thank you.
I wanted you to successfully complete this program without going to prison, but unfortunately you chose otherwise.
Yes, Your Honor.
So take advantage of any internal program that Department of Corrections might offer and earn every day of good time credit that you can to earn your earliest possible release date.
Yes, Your Honor.
Obviously, any additional fees will not be assessed in either case. Anything that was previously owed is declared by the court to be immediately due, payable, and collectible to the extent anything is unpaid. With those rulings made, Ms. Norris, are you needing direction from the court on any other matter in this case?
No, Your Honor, thank you.
Okay. Mr. Favre, anything further?
No, Judge, thank you.
All right, very well.
Um,
I'm obviously going to return the custody of the defendant to the Butler County Sheriff's Office until his custody can be transferred to the Department of Corrections to serve the remaining balance of the modified sentences imposed here today.
Since I'm getting sent off to prison, is there any way that I can request that the no contact order with my mom be dropped so I can call her and stuff like that?
Judge, I believe his mother's present on the hearing if she would like to speak to that.
Okay, I understand. I think she was a victim in one of these cases.
Yes.
All right.
Your Honor, that's correct.
And Judge, she's messaged me right now and asked that from her, and she would like it to be dismissed as well. So she
Like it
just
be
sent me that
dismissed?
message. No, she would like to have the no contact order dropped as well.
Oh, okay. Okay. Does the state oppose this request?
No, Your Honor, and generally, once the court revokes to prison, anything that the court ordered on probation is no longer an order or viable. So I don't see that the court really has to change any ruling. I think that's just that it ceases to exist.
If mother wants to contact son or son wants to contact mother, quite frankly, I don't have a problem with it.
Thank you, Your Honor.
If she doesn't, this court doesn't. In fact, I actually encourage that conversation. And
Thank you, Your Honor. I really appreciate that.
Very well.
Can I talk to Mr. Favre when this ends?
Yes, let's put those two in a breakout session before he's taken away. Mandy, if you'll go ahead and do that, we'll recess that case and move on to another matter on the docket. Favre, are you ready to go on Guthrie?
I am, Your Honor, yes.
Right, we're still recording and broadcasting, Mandy?
Yes, Judge.
Very well. Next case that the court will call is State of Kansas versus Stephen Guthrie. It is case number 2023 CR 300-014, Amber Norris appearing for the state. Joseph Favre is defense counsel. Mr. Guthrie appearing from the court security Zoom location at the Butler County Judicial Center. This matter comes before the court at this time for review of the defendant's status on probation. Court will note that the court imposed a sentence on a possession of methamphetamine case back on January 12 of 2024. Even at that time, the court was informed that he may be facing revocation in Sedgwick County case numbers 22 CR 803 and 23 CR 710. And this case was to run consecutive to both of them. At that time, he received 33 days of jail time credit. It's quite obvious to the court that Mr. Guthrie has now satisfied any obligations that he might have had to the Department of Corrections. And so the matter comes before the court at this time to determine what, if anything, needs to be done regarding this current case before the court. Ms. Norris, what is the state's position regarding Mr. Guthrie?
Your Honor, the defendant wasn't able to report, looks like because he was in Norton. This was filed in July. Your Honor, the state's recommendation was going to be that because he had been in custody, the state wasn't going to recommend a sanction, but that he did need an extension to complete all of his probation conditions, and he had not reported. And the court would obviously need to deal with additional attorney's fees and the like. But yeah, he was initially sentenced on January 12th of 2024. And I don't, like I said, I don't know whether or not he was in custody this entire time. But I believe the warrant was filed because he had not been reporting, and that may have been because he was in custody. But for him to complete, we would need to do an extension of his probation.
Is there anything that you would add to the prosecutor's statement, Mr. Ketley?
That's pretty much accurate, Your Honor. He was in prison almost the entire time we had him, and so his case was set to expire, and he had not completed any of his conditions of probation, so I had to file a warrant to place a hold on him.
I see that. All right. Mr. Favre, your position here?
Judge, that seems to be a factual statement of where we are. I'd recommend the prescribed recommendation by Ms. Norris that we go ahead and just reinstate and extend, or at least just extend. I'll just note for the court, Mr. Guthrie tells me he's gotten out. He has employment now. It's a good job, $24 an hour at the company that makes telephone poles. He's at a sober living house, and he's reported twice to Mr. Ketley since he was released from custody. I think the court had some hand in that, but that was a week ago. And anyway, he's very grateful. He's doing very well at probation so far.
Mr. Guthrie, do you have any statements that you wish to make?
Just being released, sir. I've been to an NA or AA meeting every night. I've been out. I got a job at Belmont Industries, which is probably the best I've ever had in my life. I start there next Monday. I went to SAC. I start my outpatient treatment next Tuesday. I was voted into the house last weekend. It's a great place, most positive place I've ever been in my life. This is the most positive point I've ever been in my adult life. Got a full head of steam, and I'm just ready to start doing good. I reported to corrections and parole. They're satisfied, So.
Mr. Guthrie, did Philip Webb indeed come at noon on Sunday, September 28th and pick you up?
Absolutely. Yeah. And I would like to, on a side note, I'd like to show my appreciation, my gratitude towards you for having to vote of confidence in me and let me out of jail. I won't let you down.
You know, Mr. Guthrie, I don't often believe everything a defendant tells me at a revocation hearing, but I believe you. I think you are properly motivated now to be successful and stay away from any horrible drug that might drag your life down.
Absolutely.
Pleased that the Sober Living House appears to be something that's working for you. And that you could get to work from there each day. There's transportation available to you.
I've got a bicycle. It'll work for now.
Well, I admire that too. How far apart are these two facilities?
Well, it's out there by the DCS office. It's out there a little bit, but the kind of money I'm making, sir, I'll be able to have my driver's license. I owed 400, my driver's license paid off. I'll have that paid, make my first check, and within a few checks, I'll have enough to buy a car. It's a really good job.
Well, the court made some extraordinary efforts here to get you released a little early before this hearing to see if things would work out the way you were planning to. Apparently they have. I'm
Yes, sir.
proud of you, Mr. Guthrie.
Thank you, sir.
We are going to keep you on community corrections for a while. Mr. Ketley's going to keep a watchful eye on you, and it'll help motivate you to continue to be successful. I have no reason to believe that you won't be 100% successful, but you've got some requirements to meet in this case, and the court will
Absolutely.
extend your probation and give you the opportunity to complete those requirements.
Thank you, sir.
We will extend probation for 1 year from the date of original expiration, as I understand that. That would have been on or about July the 12th of 2025, Mr. Ketley.
I believe so, Your Honor. Yes.
So I'm extending to the date of July 12th of 2026. The court will not assess any additional fees to Mr. Guthrie at this time. Anything previously assessed needs to be paid, obviously.
Yeah, $720, sir. I'll have it paid off soon.
Good. Glad to hear it. So extension to July 12th, 2026. No additional sanctions will be imposed at this time, and no additional bids assessments. All right. Is there anything else that we need to specifically cover in this case at this time, Ms. Norris?
I don't believe so, Your Honor.
Mr. Kelly, does he know when the next reporting requirement is for you?
I believe he does, Your Honor.
Okay.
Next Tuesday.
Anything further, Mr. Favre?
No, Judge, thank you.
All right. Good luck to you, Mr. Guthrie. I hope you make
Thank you, sir. Have a good day.
There's nothing
Good job,
further. The
everybody.
Stephen
Hey.
Guthrie matter will be in recess. All right, Mr. Watts, we're ready to proceed now?
I hope so, Your Honor. I'm not sure I can give you an answer as to how Mr. Chairs wants to proceed.
Okay, well, let's get Amber on here.
Clear.
Let's get the case called. Thank you, Ms. Norris. All right, Mandy, can we fully resume recording and broadcasting if there's been any pauses?
It is recording and broadcasting.
Thank you. Court will next call State of Kansas versus Jeffrey L. Chairs. It is case number 2022 CR 479. Jeffrey Chairs appears at the Butler County Detention Facility Zoom location. James Watts is defense counsel. Amber Norris on behalf of the state. This matter comes before the court at this time for hearing on a warrant to show cause alleging probation violations as alleged by Mr. Bauer, his court services officer. Failure to make payments. He's never reported, not provided proof of a drug and alcohol evaluation, had moved and not reported it, was arrested and didn't report it.
I didn't move, sir.
And those are the allegations before the court.
I
What are
didn't
your
move.
clients, what's your client's position regarding those allegations, Mr. Watts?
Your Honor, I've been attempting to ascertain that for the time I have been in there. It's not clear to me still whether he wishes to agree he's in violation or wishes to have a hearing on that matter.
Sir, if I'm in violation,
All right.
how,
Mr.
how
Chairs,
come-
your face is kind of off screen. Why is that? You need to sit up a little more or something? Okay.
sir, I'm so upset. I don't know what to say. I'm 65 years old, man. I got disabilities, man, that kept me from doing things, and I got sick. And trying to go to the hospital, and I had like I was trying to tell him, I had a warrant before I was put on probation. So for trespassing and I had my arm broke and stuff. I mean, I I wasn't even trespassing. I was in my car sitting on the city street, and they snatched and they beat me up and broke my arm, my left arm, before I was even put on probation. And so I, I was already had a warrant after I
Right.
even got put on probation, and that's what
All right.
kind of threw me off. Was it took my telephone and everything, and I had a hard time trying to get back with Miss Lori. I was homeless at the time, but I had moved. She helped me establish my place. I didn't want to lose my place. I ain't still trying to keep my place, man. And I did go through the whole year. The only thing is, if it's not about the money, I'm just trying to. I was trying to get the money together
Okay,
so I could send it
okay,
when I got out of jail.
all right. Mr. Chairs, I'm gonna hold off right there, Mr. Bauer. I'm going to administer an oath to you at this time. Raise your right hand, please. You
Yes.
do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
I do, Your Honor.
Yes, sir.
All right, Mr. Chairs, I'm talking to Mr. Bauer from Court
Oh.
Services right now, okay?
Yeah.
So you just listen for now, okay?
Yes, sir.
All right. State your name for the record, please.
Anthony Bauer.
All right. Ms. Norris, do you wish to conduct questioning?
Your Honor, the state can, although, based on notes in the file, it's my understanding that, I guess the plan, at least from Mr. Sweeney's perspective, was going to be that, defendant be granted credit for time served and that the, costs and fees go to collections. I think based on the amount of time that he has been on this case, because it is quite old, and that, this case be closed out.
Well, okay. Well, the problem is, I think even to get to that far, to a disposition, I need to have findings of violation, which I certainly haven't heard a stipulation to violations at this point. So,
Your Honor, I would agree that what the defendant was saying did not sound like any stipulation. And so, Your Honor, I can question Mr. Bauer at least briefly about what's been going on with this case. It has been going on since 2022.
then please conduct that examination, and I'm sure you'll be concise in your presentation, Ms. Norris.
Yes, Your Honor. Please state your name and occupation for the record.
Anthony Bauer. I am a court service officer 2 for the 13th Judicial District.
And Mr. Bauer, are you familiar with the defendant, Jeffrey Chairs?
I have spoken to him one time. I have never met him. I took this case over in July from CSO McManus, who left our office and went to another office, but I am familiar with his case.
Okay. And did you request a warrant on Mr. Chairs?
I did.
And why did you request a warrant on Mr. Chairs?
Based on our notes, he missed an appointment on March 14th of 2024, August 15th of 2024, December 2nd, 2024, January 14th, 2024, and has never reported since then.
Okay. And you said that you have spoken to him once. When was that?
I spoke with him a couple weeks ago. He called me from the jail, wanting a phone number for his son.
Okay. And so it looks like the request for revocation was filed. It was at July 3rd of 2025.
That is correct.
And just out of curiosity, had there been previous extensions filed in this case?
There was an extension done.
in October of 2024, extending it to October of 2025.
And do you understand there to be an outstanding balance in this case?
Based upon Odyssey, there is still a balance of $578 in this case. His last payment was July 9th of 2024.
And did he complete an evaluation and or drug alcohol treatment?
According to the notes in the file, he never did. There is not any drug alcohol evaluation in his file. I have not seen any. He has not provided any to me showing that he's ever completed an evaluation.
And based on that, you don't have any information that he completed any sort of treatment then as well?
Correct.
And looks like there are additional violations regarding his moving and then also him being arrested. Can you elaborate?
A letter was sent to his address that we have on file, and it was returned undeliverable. And then he was in the Sedgwick County Jail. He was arrested in January of 2025. In March, he was still in jail. In 2025, he was still in jail there. He got released in March. And he has never called and reported to me or Miss McManus based on notes. He's never called and reported that he was ever had that law enforcement contact and was ever in custody.
Okay. And then when you talked to him, when he called you from the jail, did you discuss at all his the address? You said you had mail come back from the address that you had on file?
I did not discuss the address with him. He called asking for his son's phone number because he needed to contact him. And then he stated he didn't know why there was a probation issue other than he's not making payments and he doesn't have the money to pay. And it was extended just so he would have to pay.
Okay. And the last known address, was that an address on in Wichita?
Yes, it was an address in Wichita on Vesta Drive.
Okay. And you said that that mail actually came back as undeliverable? Is that?
Yes, it was returned to sender, not deliverable as addressed, unable to forward.
And he did not contact your office to update his address that you are aware of?
Not that I'm aware of. That is the last updated address we had on him.
Thank you, Mr. Bauer. I don't think I have anything further at this time.
I hadn't stated that address.
Okay, just a second. Mr. Watts, do you have any questions for Mr. Bauer?
No, Your Honor, thank you.
All right. All right. Do you intend to present any further evidence, Ms. Norris?
No, Your Honor, thank you.
Do you, Mr. Watts?
No, sir, thank you.
Court, based on the evidence presented, finds that the defendant had not made any payments in this case, has never reported, or if he's had only one contact with his current court services officer, and has not reported changes in his status, and reported formally in the manner that was originally ordered by the court, that he's failed to provide proof of a drug and alcohol evaluation, had moved and not reported it. The court finds these to be substantial material violations of the terms and conditions of the defendant's probation. We'll now turn to disposition in this case. Ms. Norris, again, can I get a formal recommendation is where we go with Mr. Chairs from here?
Your Honor, as previously noted, this is a 2022 case. Defendant was placed on court services probation on October 10th of 2023. Um, defendant had an extension of probation in October of 2024. And obviously we're here now on a warrant to show cause. Defendant has not paid on this case, and based on his statements here today, it sounds like he has had several personal issues that have interfered with his ability to pay and or to report. And also it sounds like maybe some health issues. Your Honor, it does not appear that the defendant is a very good candidate for probation. As the court noted, he has multiple issues reporting that we've talked about today, and reporting in person, and then also just reporting what's going on with his case, with his life. So it does not appear that extending him on probation is a worthwhile endeavor for this court. Would ask that the court revoke the defendant's probation, and defendant has a 6-month underlying sentence in this case. As of this date, he has served 53 days in the county jail. So we would ask that the court give him the requisite amount of jail time credit, and the court will need to modify the sentence, or if the court wishes for him to serve the entire 6 months, that's not necessarily the state's intention. And also any additional waive any additional attorney's fees, and Your Honor, all the money that's still due and owing, ask that be forwarded to collections.
I understand your recommendation, counsel. Mr. Watts, your recommendations regarding an appropriate disposition here?
Your Honor, we join the recommendation of the state to give credit for the time served, modify that sentence and remand, and send the rest of the monies owed to collections.
All right.
Mr. Chairs, this case, well, let's just put it bluntly, he's been homeless more than he's had a place to stay. Mr. Chairs has noted when the time I talked to him repeatedly that when he was arrested in Sedgwick County for a trespass, an arrest that he doesn't believe was justified. He's mentioned several times that they broke his arm during that arrest. He apparently lost his phone during that arrest. He was unable to make contact with anyone. It sounds like he tried to call Mr. Bauer looking for a phone number for his son. He has struggled, and that's being kind, with being able to do any sort of probation here. And it doesn't look like this is one that he's going to be able to do. So we would join the state's recommendations to terminate this matter.
Understand, Mr. Watts. Thank you. Mr. Chairs,
Yes,
I
sir.
will turn to you and I'll ask you if you have any statements that you wish to make in mitigation of punishment here.
Sir, I've been staying where my apartment is right now on 1421 North Spruce Avenue, apartment 301, zip code 67214, since right after I got put on probation. I never moved nowhere.
Okay. Anything else?
I hadn't been on Vesta Drive for I don't know how long before I got, yes, I had moved from there a long time ago before I even caught that case.
Mr. Bauer, do you have any independent recommendations or information that you would provide the court?
Your Honor, I don't have any further recommendations. I would be in agreement with doing a modification on his case. I don't think he's going to be able to comply with this for various reasons.
All right.
Sir, if I had at least a month, I could get the money. If it ain't about the money, I mean, I do the drug evaluation. I just got threw way off. I got dyslexia. I got this. I have this same
Dyslexia?
disability. My disability that I have a hard time remembering things, and I can get I can I can I was trying to get the money. Is what I was trying to do mostly before this even happened, sir. And I could if I had a couple of weeks. I get the
Mr.
money.
Chairs, I'm sure you're stating to the court in good faith here, but if you were going to pay this case off, you'd have done it by now.
Yeah,
If you were going to get a drug and alcohol evaluation, you'd have done it by now.
yeah.
I don't think that adding additional probation time in this case to allow you to meet requirements that I don't think you're ever going to satisfactorily meet is really the right thing to do here.
Sir,
The court can excuse not having any money. There are a lot of poor people in the world, Mr. Chairs. You very well may be one of them.
I understand.
I can excuse that if you don't have the resources to get not getting a drug and alcohol evaluation, though, if you would have worked with your CSO, they could have set that up for you. But
I was about
I'm not going to be too critical. Why don't you just hear me out?
Okay, sir. I'm sorry.
All right.
Yes, Your Honor.
As far as moving and not reporting it, I don't understand. Not communicating with your supervising officer, I don't understand, and missing appointments. Mr. Chairs, even if you lost your own phone, I can't believe in this world where just about every single human being walking has a cell phone, that you couldn't at least borrow a phone if you didn't have one of your own to make a call to court services and let them know what's going on with you. Of all of the things this court can forgive, that's something I can't forgive.
Okay.
That you simply didn't communicate and report either in person or through phone communication or some other means with your court services officer. But there's a lot of practicality involved in what has been recommended to this court, and to a certain extent, the court adopts the rationale here. I'm a little uncertain about computation of jail time credit, and it'll be the order of this court. If this court will order the defendant Jeffrey L. Chairs to serve 48 more hours in the Butler County Jail as a sanction for noncompliance. To this point, Mr. Chairs, you've been in jail because you couldn't make bond. But I want you to know that there's a specific order of the court extending your jail time because of the findings that the court has made here today and the orders the court has made here today. But I do agree with Ms. Norris in the county attorney's office, echoed by others in this court, that I think we should terminate this case at the end of that 2-day period. Now, that very well could mean that the journal entry in this case will show that your sentence has been modified downward to what appears to be 55 days. But I do want to make it clear that I am adding 2 more days onto his sentence, whatever the proper computation would be. I know for sure we're not going to go beyond 180, which is the 6-month sentence that the court originally ordered. But I will modify it to whatever number of days he has served in this case after 2 more days are served. And it could be that the county attorney's office previous computation is exactly correct, which will essentially mean that there's a 55-day sentence. He served 53, 2 more to go. But about this time, 2 days from now, Mr. Chairs, you're going to be released.
Thank you, sir.
And your case is over with, except for the fact that you still owe money. And I'm going to, if it hasn't already been turned over to a collection agency, I'll declare it immediately due, payable, and collectible. And so
Yes,
they can take full action to collect that money if they can find some way to collect it from you, Mr. Chairs.
I sure thank you, sir. I thank you too, ma'am. And
I just hope your life situation improves at some point, Mr. Chairs, and that you don't get in any further trouble.
oh, I sure thank you, sir. I hope to see you again in a better circumstances.
Perhaps under better circumstances, Mr.
Yes, sir.
Chairs.
Yes, sir. That's what I'm trying to say. Yes, sir.
All right. Ms. Norris, do you need any further clarification regarding the court's current order?
No, Your Honor, thank you.
Thank you. Mr. Watts, anything further at this time?
No, sir. Thank you.
Oh,
Okay.
man.
Mr. Chairs, do you know what's going to happen from here?
Yes, sir.
What?
You said 2 days.
Yes? That part you understood pretty well.
Excuse me?
And then you're going to be released and your case is going to be over.
I sure thank you,
Except
sir.
for the money you owe will go to a collection agency for further handling.
Oh,
Okay.
I sure thank the way you explained it to me, sir. And
All right. Very
and
good, Mr. Chairs.
I
Good
sure
luck to you.
thank you so much, sir. I sure thank this blessing you gave me.
Well,
Because I'm just
if it's
living
missing
for
the
day
case,
to
I'm just
day,
declaring it terminated
living for
after you serve a couple
today,
more
and
days, but
not thinking about tomorrow. Just living for the day, sir.
okay. All
Happy
right. Good
birthday.
luck to you, Mr. Chairs.
Thank
If there's
y'all.
nothing further,
I sure thank y'all. Appreciate y'all.
the chair's matter will be in recess.
All right.
Folks, this should conclude the docket. Have a good weekend, folks.
Say that one more time.
Judge,
sir.
you too.
Thank you, sir.
We will go on the record in the matter 24 CF 228, State of Wisconsin versus Andrew Alden. The state appears through District Attorney Kevin Schmidt in person. Mr. Alden appears in person in custody with counsel Nicholas White. We're set here today in this matter for the sentencing portion of the case. Mr. Alden pled guilty on June 4th, 2025 to one count of possession with intent amphetamine, methamphetamine, greater than 10 grams, but less than 50 grams, a Class D felony. The court ordered a pre-sentence investigation report. The court has received and reviewed that report. The court has also received an alternative pre-sentence investigation report. I have also reviewed that report. I believe that was all that was presented to the court for its review. I do not believe that I found anything that jumped out to me that would be an error or a material error in the either of the reports. Mr. Schmidt, did you receive a copy of both documents?
I've received them. I've reviewed them. I have no corrections.
All right, Mr. White.
Thanks, Judge. I did receive both of these documents, filed the alternate PSI. The only errors or omissions that I noticed in the DOC PSI would have been the criminal history. And for the most part, that was updated correctly in the alt PSI on page 7. The PSI makes a couple mistakes of Mr. Alden's history. For example, they state that he served a year in jail. That's not true. He only served 3 months. So that'd be just an error on page 4. There's a number of just other kind of errors or clarifications there. With the case 20 CF 190, he did have an imposed and stayed sentence. Never had to serve that. And I would just, I guess, direct you to page 7 of the alt PSI that confirms things from CCAP. For example, Burnett case 2005 CM 74. I have no access to that case. Somehow DOC found it, but I have not been able to. Must have been expunged or something. And that's it for errors or omissions.
All right, thank you. Mr. Alden, did your attorney go over both of these documents with you?
Yes,
And
yes,
you reviewed them very thoroughly?
pretty much, yes.
And so the errors that Mr. White stated on the record were the only errors that you recalled or you were able to point out as well?
Yes, yes, I've never sat this long in my life.
All right, okay. Mr. Schmidt, I'm going to turn to you for argument and sentencing recommendation.
Thank you. According to the court's PSI, DOC's recommendation is 8 to 15 in and 4 to 5 out. My recommendation is going to be towards the lower end of DOC's recommendation. It's going to be 8 years initial confinement, 4 years extended supervision. Going to be recommending that the court make Mr. Alden eligible for the substance abuse program and the early release program after being in custody for 4 years. When you look at the offense and the read-ins, it encompasses Mr. Alden possessed large quantities of methamphetamine on 2 occasions. Quantities and paraphernalia gathered indicated that they were for sale, not just for personal use. He also had a large amount of cash, despite claiming destitution and being totally reliant on a small amount of SSDI. that's suggestive of not just selling to support a habit, but selling to support more than that. I think the goals for this sentence as a result should be rehabilitation, specific deterrence, and general deterrence. So right off the bat, the sentence should not be probation. The court should strike that out right at the beginning. The reason why is in the past 15 years, Mr. Alden has had, by my count, 8 convictions, 6 of which ordered probation. He's been on probation for, from what I can tell, about 12 years. If a person is not only not getting better after that much time on supervision, but getting worse, moving from simple possession, which encompassed the vast majority of his criminal history, into actually dealing, then that shows getting worse over time, not getting better. It demonstrates that despite probation being the initial response in all these past cases, we're getting digression, not progression. So probation can't be the answer, especially if an offense is committed while on supervision. So with probation off the table, I think we're really talking about how much incarceration would be appropriate in this case. And another reason to know that incarceration, there has to be at least some of it, is obviously gravity of the offense. I think that just doing jail that is not prison would unduly depreciate the seriousness of the offense, which is the possession with intent. Sometimes with possession with intent crimes, especially if it's the first time the person's been convicted of it, we might consider that in those cases. But here, given it's 2 separate incident states encompassed in the offense and the read-in, I don't think that is appropriate here. I think such a sentence would violate the McCleary-Gallion factors and have a negative effect on the goal of deterring the public generally. So how did I come to how much prison we have here? So with Mr. Alden's priors, all but one of the priors were simple possession offense. The only one that wasn't was a receiving stolen property offense that was 14 years ago. The history tells us that Mr. Alden has an extremely pervasive, hard to defeat substance abuse disorder. Part of the reason probation should be off the table is because of that, because he's done everything on probation. He's done everything you could do for treatment in the community, and it hasn't worked. That means treatment in a confined setting is what would be ideal for Mr. Alden. And what's available in the county jail is not going to be better than what he's done on probation in the past. When I say the treatment in a confined setting that he really needs, I'm talking about what's available through the substance abuse program in the Wisconsin state prison system. That is the next graduated step up from a person who's done every conceivable program, who's done drug court, who's been on supervision numerous times. That should be where we go next. I think that's the best bet at actually curbing what is the driver, what you can definitively say is the driver, and at a bare minimum, all but one of his convictions, and probably very likely, given it was receiving stolen property, probably involved with that as well, just because we often see a nexus between those. I haven't reviewed the specific facts of that offense, but we just know there's a connection between thefts and receiving stolen property and people having substance abuse disorder. So I think that treatment in confined setting, Wisconsin prison system, earned release program, substance abuse program, that's the next dosage up from what he's had so far. I think he needs enough prison to ensure that he can complete the substance abuse program in prison. He has an enormous amount of credit now. I think a statement, I can't tell if it's Mr. Alden or if it's Mr. White, who said this right now has been the most time he's been in custody. It is 366 days. So 1 day over an entire year already is what he's at. So if the court did a short enough prison sentence with that much credit, he might not even be able to do ERP, because you need to be in long enough to do the program. And if there's a waiting list, to get through the waiting list first. I know being lower risk, and I know being closer to the end of your sentence moves you up that list, but I think we need to make sure he has enough time for that. So that's part of why in my recommendation, I position the 4 years ERP eligibility at 4 years, because then we know he's going to be able to get through any waiting list, that he's going to be able to do the programming and actually be able to do it in prison, the substance abuse programming in prison. no matter how he gets categorized 1 through 4 on his risk assessment that the DOC does, no matter how long the waiting list is. I think that's something that's super important in this case, the ERP program. I'm probably getting repetitive with mentioning it. I think it's so important in this case. In terms of why am I arguing for 8 years initial confinement on this? When we have normally for a first-time drug dealing offense, I'd probably recommend something more in the terms of 3 to 5 years initial confinement, but I'd argue much less. I'd still argue they have to sit quite a bit of time before the ERP eligibility. In this case, like I said, since it encompassed really 2 acts at different times as part of one course of conduct, I thought it appropriate here 8 years. Because quite frankly, if I did charge this as 2 complaints, which would have been another choice, I think that's what we'd be talking about anyways, just given the multiple ways there can be for charging and viewing the behavior. So yeah, I think 8 years initial confinement, given what the maximum minimum penalties are, encompasses what I'd call a high end of a moderate sentence. It's right at the threshold before you'd say it's a big sentence or a small sentence for a high level offense. Say if somebody had 100 grams of methamphetamine. I also think it's important here to not make Mr. Alden immediately eligible for the ERP program. The reason for that is I do think he needs some time incarcerated as a form of punishment for specific deterrence of purposes and capacitation. The large amount of money, the multiple instances of large amount of methamphetamine demonstrates he's been a larger problem in the community, so incapacitation has value in terms of protecting the community from Mr. Alden's distribution of controlled substances. I think specific deterrence is important here because of, quite frankly, how Mr. Alden kind of describes his own conduct in the court's pre-sentence investigation report. It kind of concerned me that he used phrases like being snitched out and describing about how he got caught, because that sort of terminology really suggests a belief that if the person who got you in trouble did something wrong, because snitching is a pejorative term for somebody telling you, it's a negative term for it. And it suggests that if they view that as problematic behavior or bad behavior, then it shows a different type of view of their own conduct rather than accepting responsibility. Like, I'm glad that person told on me. I'm glad I can put an end to this behavior. It's instead, I'm here because someone snitched out on me, which is not good when we're looking at terms of breaking criminal thinking, changing cognition, which is a really important factor, especially when even the sentencing memorandum from the defendant, when they went through their own compass, still showed Mr. Alden being pretty high risk, pretty high need in that assessment. It shows we don't just have substance abuse issues to tackle, we have criminal thinking problems to tackle. So that was something I wanted to draw attention to. The court might want to consider, no matter what it does, doing something related to mental health aside from substance abuse, just because of the incident of Mr. Alden trying to harm himself back in February in the jail. I think that would be something to look at as well. It could have just been related to fear of the consequences of this action or being incarcerated, as he explained, longer than he ever had been before. But in any case, it's probably a good idea to do that as well. Often substance abuse disorder is tied in with mental health issues as well. So to sum, again, I'm asking the court to do 8 years initial confinement, 4 years extended supervision. That's the low end of the court's pre-sentence investigation report. And to put the eligibility for ERP at 4 years, so because that's just what I think is the sweet spot for accountability and doing some specific deterrence with some time that's guaranteed in prison, and also making sure he can get the maximum benefit of the substance abuse program. Because if he's going to get rehabilitated, we've got to do what's new, and what's new for him will be that program, treatment and confined setting. Thank you.
All right, thank you, Mr. White.
Thanks, Your Honor. I want to go over just some of the charges here having to do with the gravity of the crime and work from there. This is a case that had a number of charges read in. And Your Honor, these are all items that were either found in my client's vehicle or on his friends or in his home and that kind of area, maybe garage and on his property. He did admit to the count two, specifically because the count one there, although it is dismissed and having been read in, it's pretty clear, even just reading the complaint, depending on how much of this you believe, that item related to count one belonged to Mr. Timothy Frisco. He even told the officers that, and I think it's made more clear from review of the discovery. I heard the prosecutor refer to that charge quite a bit and this having multiple dates. Your Honor, those items belong to somebody else, and that's not the charge that we're here to sentence on. Just going from there, this is serious given the amount of items, even just something as simple as paraphernalia. There is a volume of that found in Mr. Alden's home. I'm not sure what the comments about a large amount of cash refer to. I thought there was only $500 here, and what's that?
I think it was 500 or something.
I believe that his bond was much more than that. I wouldn't consider that much money myself. This is not a case where you have a person who is dealing out of his house repeatedly. We don't have CIs going there to purchase. This case was effectively initiated by the comments related to snitching or Mr. Frisco pretending to be Mr. Alden's friend when he was really a CI. And that's how that arrest started, and I think it was a basis for the search warrant for the home search on October 3rd. We would recommend that Your Honor consider a mixture of what my author recommends in the all pre-sentence investigation. He looked into drug court and just the history there where Mr. Alden did succeed. That's referenced in the DOC PSI as well, that when people are strict with him, when he's on probation, when he's got a strict agent, when he has treatment court or drug court, he does well. He's told me that himself, that the times that he succeeded on probation, he had stricter agents. They didn't let him get away with as much, and that is to his benefit. My notes here is that he has 2 felony prior convictions, 7 misdemeanors, that he was put on probation 6 times, and he was only revoked once, and he was only in treatment court once, and he succeeded. It seems that he does succeed on treatment court. He does succeed on probation. We're not recommending probation today. I think that the seriousness here, Your Honor, just to be honest, this has to be a prison sentence, but we're asking for you to consider something a little bit less. My author suggested a 5-year total prison sentence, split evenly, which would be 2.5 years of confinement, 2.5 years of supervision. And that's what I'd ask you to consider for today, and to also include a treatment court component upon release. The concern there might be just that if Mr. Alden is on treatment court in Burnett County, it doesn't allow him to leave the area. And after looking at the PSI, that's something I think he really needs to consider, is either relocating or starting over with a new group of people. He is somebody who does not stick up for himself, and I don't know if that's just his life history, but he does have a lot of history of PTSD and bullying since from when he was a child. Both reports suggest that he has a very difficult time saying no to somebody, and that's not good when he's around people that are using or dealing. They expect things out of him, and if he doesn't have it within himself to say no, he's going to be in worse situations. Looking at his character and rehabilitative needs, he has, well, he has some mental health issues and he's got some learning issues here. I think that the list here of anxiety and depression, PTSD, and ADHD from when he was a child, and then that just increasing to severe depression, physical problems like a hernia and heart problems. These are things that I think are just going to be made worse by the prison sentence and the prison setting, particularly the depression. Your Honor, is my personal concern there. After hearing about Mr. Alden attempt to take his own life in this jail, and my own belief this jail is not as bad as what prison's going to be like for him, I'm concerned that Mr. Alden truly might not survive his time in prison. Either anxiety related to heart issues and those combined, or just the depression and his own lack of self-esteem, and that combination is going to make this a very tough sentence for him to serve. The Compass report or assessment there had him at a higher risk, but it was not aggravated. And I think that's where the prison recommendation is necessary here, for better or for worse, from just from a sentencing point of view, but also for Mr. Alden's own benefit. This is a prison case, but it's not aggravated. So, Your Honor, I'd ask you to look at the smaller end of the sentencing there. And kind of just to finish up some of the conversations I've had with Mr. Alden, we've talked about him only ever serving 3 months in jail before. That was an important correction to the PSI, just because we know sentencing should be somewhat graduated. If Mr. Alden had never been on probation before, I might recommend it today, but he's had it, he's had chances, and we're recommending prison, but he's only ever served 3 months up until now. He's had the last year in custody outside of a short furlough for medical reasons. He's had a year in confinement to sober up, to start changing his outlook on life, to learn the lesson. We'd ask you to consider ERP upon immediately. That'd be ERP eligible through the substance abuse program. I'm making that recommendation, but I actually did not factor in any kind of prison wait time with that recommendation. And I would trust the prosecutor's assessment of that independently. But looking at my client's goals, whatever Your Honor sentences him to, it's not going to be indefinitely. Looking optimistically that he survives prison and he's released, he's going to either have to sell his house and move, likely live with someone related to him, live with a family member if he can. But like I already commented, he needs to consider relocating, finding somewhere else. He doesn't have to work. He's likely not able to work because of his disability. He's had the SSDI for quite some time. As the alternate PSI author noted, unfortunately, that's really to his own detriment. As nice as it might sound to get this check in the mail every month for not having to work, in the long run, by not working, it gives Mr. Alden just too much time on his hands. This has not been something that he's used appropriately, and I think that's part of the reason his criminal history is the way it is. We've talked about his schooling. He was close to finishing high school and then moved and found out that it would take a number of years to complete it, so he never went back for GED or HSED. I think he needs to do that. Not necessarily to go out and find a new job, but just for his own mental health and development, maybe his own self-esteem. I think it could help him out there and thinking through things. We've talked about therapy. He's admitted that counseling has helped him a lot in the past. He was in treatment with Whole Life Services at some point, I think in 2024, before this arrest. He's currently been accepted into treatment at Salvation Army. So he would have options for either just counseling, mental health help, or actual substance abuse therapy afterwards. While he's been in custody here, he has attended the anonymous meetings when it's been available. Sounds like there's just an issue with numbers once in a while. Your Honor, I reviewed both of these recommendations, and I'd ask you to consider that the best recommendation, sort of a combination of these with a short confinement portion and likely a requirement for him to at least apply to a treatment court with wherever he's going to be supervised upon release. That's all I have for you, Judge.
Thank you, Mr. White. Mr. Olden, would you like to make a statement here today? You do not have to, but it's your only opportunity to let me know anything you would like me to know, anything that may not have been stated by either side, or to correct some things that may have been stated as you believe to be incorrect.
Your Honor, I have said this is the longest I've said. I've truly learned a valuable lesson here. And I feel your treatment court, with a little help with you in your treatment court, I can stay focused on my sobriety. I could stay with my parents, and my house has been cleaned out. I'm ready for it to either be rented out or up for sale. So I won't be returning back to there. I think a new place to live would be best for me, or somewhere new. And even if having no contact with no users or anything would help. I know that. That's about it.
All right, thank you. Thank you, Mr. Alden. Mr. Alden, the first thing I want to let you know is, well, you've been in front of the court various times for nothing as serious as this. And as you've stated, this is the longest time you've been incarcerated. The longest was 3 months. There is a vast difference between 3 months and 1 year of incarceration. There's an extremely bigger difference between jail incarceration and prison incarceration. Some things, I've had people say, some things about prison are far better than being incarcerated in jail. Some things are worse. But still, it's prison, and it would be your first prison sentence. In order for you to be on a better path, a different path, you have to change your habits. You have to change your associates. You have to change yourself. And in doing those things, you can significantly improve your life and not be in that seat wearing orange again.
That's what I would like to do.
You need to not only modify your personal habits, but you have to actively surround yourself with people who support a positive change and that align with your desired goals, the goals that your attorney listed that you have for your future. You have to realize that the people that you spend time with are the people that greatly influence your behavior and they influence your mindset. So if you're with positive people doing positive things, making a positive change in this world, you will align with that and be more positive and have a better, less criminal-filled life. But if you gravitate back to the people you have associated with And I'm just going to say back to 2017, when I believe that was when I first met you, or somewhere around then, that you gravitate to those people that you have continued to gravitate towards. Your life is going to continue to get worse and worse. And it is a fact that once you go to prison, and if you are on ES, extended supervision, the more you continue to be around those people, the easier it is, and the more likely it would be that you will go back to prison. So you need to be in a place today and in the future to make those changes, to change your habits, to change your associates, and to change yourself. You've been here before in front of the court in which I have went over the certain things and factors that I have to review with sentencing. The first and foremost is the nature and the gravity of the offense. Again, this is the far most serious crime you've been in front of the court for. Otherwise, it's been possession of methamphetamine, maybe the criminal damage to property. I just recall a handful here or there cases of possession of methamphetamine, and some were reduced to possession of amphetamine, but things that were less serious. We all acknowledge, every person in this room acknowledges the severity of this offense, the intent to deliver the amphetamine, methamphetamine. And here we have 2 counts greater than 10 grams, less than 50 grams, Class D felonies. Each count carries with it a possibility of 25 years of incarceration apiece. And I know that there's argument, and I've heard from your attorney, and I know that you've argued the fact, and I've read it both in the alternate PSI as well as the DOC PSI, that with regards to count 1, that you argue and you're saying that that was not yours. You were in a car traveling with this other person, you were pulled over, and there was methamphetamine, I believe, found under the seat, and that person at that time stated, "That's my methamphetamine. It's not Mr. Olden's, it's mine." But then through the process of his case and his work with the police and their investigation, then it switched. And his statement, and especially like with this case, showed or proved that it was your methamphetamine and that you were selling and dealing methamphetamine. I know that you argue otherwise, but either way, this is a dismissed and read in count, and the court can consider that for sentencing purposes and any restitution if there is any, but for sentencing purposes, as long as the court does not exceed the maximum possible penalty for the charge that you have been convicted of. I also have to look at your character and all of that with your criminal history and what I have in front of me, what I know, and what I have in these reports. I have to look at needing to protect the public. And here, this is a community, this is a public as a whole seriousness case and needing to protect that community as a whole. And as Mr. Schmidt did state, that there are other factors for the court to consider as well. I have to consider your rehabilitative prospects. Do you have the ability to rehabilitate? Do you have the ability to take services, learn from those services, make improvements in your life, and correct your behavior and your mindset? Do you have this undesirable behavior pattern? Is this something that the court has to be worried about? Is this something that you've been engaged in previously? I have to look at your culpability, your age. I have to look at your education, your past, and that's where the other things like the trauma and the mental health and what you've experienced in your life comes into play. I also have to look at deterrence. And Mr. Schmidt pointed this out in his argument to look at general deterrence, what a sentence would do to generally deter others, other people who are considering or thinking of or actually engaged in this type of conduct, and specific deterrence, a sentence that would specifically deter you from wanting to or having any desire to or any thoughts of engaging in a crime like this again, or any crime for that matter. So the general deterrence of the whole and the specific deterrence of you personally. I have listened to the arguments of both of the attorneys, and I've heard you in your statement, Mr. Alden. You're not a man of many words, and that is okay. You have stated to the court what you want the court to be aware of and included in it a part of your plan and what you want to see in the future and how you want to change your life. I have read both of the reports and considered them, and I've actually reviewed them more than once. You have admitted, and you are admitting today, that you did in fact engage in the delivery, the sale of methamphetamine. And that is a very serious crime. It's on the top of the list of seriousness because, as you know, and as everybody else does in here, not only is Burnett County having an epidemic of an increase in substance abuse use or substance use abuse, including deaths and other things, but our state is, our country is. And I don't know how to get a hold of that. I just don't. And that's why the focus then becomes on the dealers and how to stop the dealers to hopefully stop the moving of those substances to people. If you look at the charges that you have originally you were originally charged with, and if you look at the fact of if this matter were to have went to a jury and you were found guilty on all of those counts, you would have hanging over your head a little over 57 years of incarceration. 57 years. At your age, Mr. Alden, that could be a life sentence, even though some of it's initial confinement and some of it's extended supervision. But we know, or maybe you didn't know, but I will explain it to you, that extended supervision is kind of like probation, but different in the fact that if you violate, you can be revoked off of that and be sent right back to prison and serve the remaining extended supervision time in prison. So that makes it more serious and something to think about a lot more when you are out of prison and on ES. So 57 years is a lot of time to hang over your head. You did reach an agreement with the state in which you pled guilty to one of the very serious matters. And in doing so, you limited the amount of exposure to a maximum of 25 years, 15 years of initial confinement, and 10 years outside. So you did get a good bargain in your plea deal. The primary dispute here is not whether or not you're going to prison. We all agree this is a prison case. The dispute becomes for how long? How serious is this? And does the court put a heavier weight on the fact of the dealing of the methamphetamine, or a higher weight on the fact that this is your first serious crime, your first lengthy time of incarceration, and those other factors of your history? And that's for the court to work through with regards to this sentencing. I've heard a few things here today, and I want to make sure that I can touch on them so that you can have an understanding of where the court is coming from with its sentencing. First and foremost, I need to make you aware you will never be able to be a part of our drug court or treatment court, because we do not, it's prohibited to allow people who have engaged in the sale, the delivery of methamphetamine and or any other illegal substance. So dealers are prohibited from being in our treatment court. So that is out, okay? But it does not mean that you would not be able to perhaps be a part of another county's treatment court, but you have to live in that county when you are released from extended supervision and if your probation is transferred, okay? You had a gift provided to you previously when you were a part of the Burnett County's treatment court prior to me, and you successfully graduated. That is a very positive thing. I don't know what happened. I don't know if it was your associates. I don't know if it was your trauma. I don't know what it was, but something brought you back to methamphetamine. Something brought you back to your addiction. That is what you need to figure out, Mr. Alden, because until you figure that out and you have all of the self-reflection and you understand the impact of the events that have happened in your life, you will not be able to break your addiction. You need to be the one who takes control of your life. You need to take control of your substance use. Only you can do that. No one in this room can do that. Your mother has been here, I think, every single hearing that you have been in front of the court. She is a very strong advocate for you. She has been a strong advocate. She is in your corner. She will always be in your corner. And I'm going to tell you, I know from history, just living in this county for my whole life, that she was a very successful social worker in this county for a long time. And I can't believe that she would support your substance use. I believe that she is a strong advocate of you getting the treatment and the help that you need and reaching out to those people, including your mother. And I can't see that she would allow you to continue to use and to be in her home. So that would be a positive thing if that comes down to it when you are released. Or again, your thoughts of moving outside of this county are not a bad thought either, away from the bad associates. Change your habits, change your associates to be able to change yourself. I do see that you have rehabilitative prospects. You want to succeed. I have seen that in the history with your treatment court, those types of things. I believe, I didn't have to have Mr. White tell me, I believe that you are a person who has a very difficult time saying no. And I don't know how you got into the game of selling illegal substances. I don't know how you did. But I do believe it probably comes from a lack of the self-esteem and not being able to say no. I know I read in one of these reports that it was it wasn't inferred, it was stated that you were selling to support your habit. I can understand that statement. I can understand the fact that you don't have much money. It's not like you drive a brand new vehicle or you have all of this money to go on trips and to do concerts. But I don't believe the statement that I don't believe anybody's statement that they're selling to support their habit. Because selling methamphetamine is killing our county, it's killing our people, and you have been a part of that problem, a part of that devastation. And that's the awful part, because you engaged in this type of conduct. You are not only hurting yourself, you're hurting your mother, you're hurting your father, you're hurting your friends, you're selling to your so-called friends, you may be selling to any real friends, or other people's children, or other people's parents. And it doesn't just affect you. And it doesn't just affect that person that you have sold the substance to. It is more than a trickle effect. It's a waterfall effect. And it continues to destroy household upon household upon household. And I think you understand that. I don't think it's something that was in the foremost part of your thoughts, but I think you get that. And now you have a better understanding because now you're sitting in that chair knowing you're going to go to prison. Hopefully today, and what's going to happen, and hopefully my words, the words of your attorney and of the state, will resonate within you. You will think about that and you will be able to actually turn your life around and to change and to be an advocate. I have seen people sitting in that chair turn their whole life around, find God. I'm not saying you have to find God, but find something they believe in find a purpose, and they become the biggest advocates for those who are in need, who have the substance abuse issues. And you could be one of those people, Mr. Alden. So when I'm looking at the community, I have to figure out a sentence that is not only going to be a punishment factor, a deterrent factor, but also one that is going to protect the community. So it does have to send a message. And it has to send the message not only to you, but to the community. I do take into account the trauma that you've experienced from a very young age, being burnt. I think it's on your neck. I think I can see it. You've healed pretty well over the years, but that was 20, 30 years ago, a very long time ago. But that had to be significant for you, and that did have to cause significant trauma. And that's why I can understand the PTSD and from the bullying that you had as a young child. Honestly, I'm going to tell you, as an adult, you probably experienced that as well. And you're shaking your head up and down that you do and that you have. And that could have been part of the factors for you to engage in the behavior that you have. I do have to state, though, that with regards to the dealing and the selling, you're in front of the court for the first time for this crime. But in this case, you have done it once and you have done it twice. And arguably, statistics would show that if you've done it once, you've done it twice, you've been caught twice now in this case, that it's more than likely that this is not the only 2 times that you have sold methamphetamine. You've just gotten away with it. And that's part of the problem too. And I want to say that's part of the problem for you, but it's also a part of the problem for the community and for others who engage in this type of crime. Because had you gotten caught earlier, perhaps, I don't know when you started, but years ago, let's say, you probably would have had a harsher sentence and it would have come down a little bit quicker. You could have turned yourself around at that time. And perhaps at that time, you wouldn't have had the criminal history you do now. And perhaps it would not have been a prison recommendation. Because I don't know, I have no idea when it started, and I'm not going to ask you, and I'm not going to have you tell me. But let's just say 5 or 10 years ago. 5 or 10 years ago, we didn't have this epidemic. We didn't have this problem that we are experiencing today. It would have been a different punishment, a different sentence. Had you been caught earlier, perhaps you would have already turned your life around and you wouldn't be facing such harsh recommendations for prison. That's just unfortunately food for thought. And that goes with anyone who's engaged in this type of conduct. So, Mr. Alden, I have seen you over the course of the many years, and I don't know you personally. I just see what I get to see in court, and I see how you are with your family and your friends or the other people who hang around you or have been with you. I know you've said in other cases, you've let people crash at your house and just stay at your house because they needed a place to stay. So it sounds like you have a good heart and you want to do what's right. You just haven't had the courage and the strength and the self-confidence to do so. Perhaps even the self-esteem to be able to do so. And hopefully with this sentence, you're going to be able to gain those things. So with the seriousness factor and the protecting of the public, what the court is going to do, again, I have one sentence recommending 8 to 15 years of initial confinement from the Department of Corrections, 2.5 years being recommended by the alternate PSI and from the defense. And I have 8 years being recommended by the state. And the state also has the caveat of having you sit 4 years in prison before you can engage in the substance abuse. I do want, then that's the early release programming. I do want to tell you up front that generally, I'm not saying in every case, but generally with intent to deliver substances, in particular, anything over THC, the court, I don't grant the ability to partake in and engage in early release programming because it's such a serious offense. And that's generally, it's not a straight across the board thing. And I say that because in this particular circumstance, I am, because you need it. You absolutely need the substance abuse treatment program in prison in that setting, because hopefully, maybe that's what's going to stick. Okay? So with the recommendations that the court has in front of me, I'm just looking at all of my notes to make sure that I have covered all of the things. And I do want to state also, you pointed it out, Mr. White, that when in Mr. Schmidt's argument, he said, I think enormous or significant amounts of money. I only could find in my reading of the reports and the criminal complaint, it was $500 in the trunk of the car. And I can't guess, 200 or something in his pocket. And to me, and I can go count it, it identified each and every bill that was in his pocket, 15 20s maybe, or 15 ones, not something too significant. But it is a lot of money for a person to just have on their person. And I do understand that in one of those reports to one of the people, you did state that you kept the $500 in the trunk of your car because you didn't want it to get stolen. You were saving for a new car or something along those lines. I don't know if I buy that, because I'm going to tell you, and you should be aware, everybody should be aware. It's so much easier for people, and it happens a lot in Burnett County, to steal somebody's car than it is to rifle through and go through every nook and cranny of a person's house. So it's probably easier for you to hide your $500 that you're saving to get a new car somewhere in your house, in a floorboard, in a wall, and to be able to build something in there, than it is to put it in the trunk of your car. So that's why that doesn't seem so realistic. And that's why that goes along the whole lines of the dealing. But again, putting everything together, I think I have covered all of the things that I wish to cover in this case. So what I'm going to do is I'm going to order 6 years of initial incarceration with 6 years of extended supervision. And I'm going to state that you have to sit at least 1.5 years of confinement in prison before you engage in the substance abuse program. You need that punishment portion before you have the ability to engage in what you really truly need and to be able to get out early. The earlier you get out, the more, and the time that you have remaining on your initial sentence goes to your extended supervision. But again, I warn you, it's easier to be revoked and sent back to prison once you're out. So change your life, change your habits, and don't be with the people you've been around.
Yeah.
They use you. And so be a person, it's good to give, but don't let them use you. $518 in fines and fees. And quite honestly, I'm not even concerned that that gets paid until after you're released from prison, but the Department of Corrections has the ability and the right to collect at any percentage that they determine to be reasonable while you're in prison. So that fights for you in the Department of Corrections. But this isn't restitution, so I have I have no qualms about it being until it waits until you are released from custody. As part of your extended supervision, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular drug testing. I don't think you drink alcohol, but you're not going to be able to drink alcohol either, being on extended supervision. I'm going to order a mental health evaluation and follow through. And this includes therapy until your agent or your therapist releases you from the sessions, okay? Because you truly do need this. You do. You need to find you and you need to find your strength. No contact with anyone who's on felony drug-related extended supervision or probation. And it's drug-related, not just dealing. I'm also going to order a medical health evaluation with a medical doctor to go over whether or not you should look at some type of anxiety prescription or depression prescription or something along that nature, and to take those as prescribed. Because, Mr. Olden, it's not a negative thing to have to take medications for those conditions. So many people do. So many people do. Just like therapy. I think everybody should go to therapy. It would benefit everybody. But to take medications as prescribed. To continue with your treatment, and that could be finding a different drug court that may allow it if you're going to move to another county, or a inpatient treatment facility or outpatient treatment, just to continue your treatment alternatives, okay? And that will be with you and your agent to determine. You have 366 days of jail credit. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you because you're always going to owe it, but the court could issue a warrant. You could sit up to 6 months in jail. I need your DNA. Then you will need to provide that to the jail. They will make sure that they have that. In this level and seriousness of a crime, I do not think you can have it expunged from the system, but you can request it if you wish through a written letter to the Department of Justice, not the court, to the Wisconsin Department of Justice. It's easy to do. Google or Mr. White could help you. They make that determination. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. I would like to see you and find a hobby too. And I am going to make that a condition when you are released from custody. Find a hobby, one that you can engage in and you can partake in, that maybe it's weekly, maybe it's bi-weekly, because as Mr. White said, you have too much time on your hands. Idle hands are the devil's workshop. And you have shown that. You have done that. Because you have so much time, you get bored and you find friends and they haven't been the best and they've brought you down. So find a hobby. I don't know what it is. I don't know what you like. Hopefully you can think about it. Maybe you like to whittle wood. Maybe you like to paint, or maybe you would like to garden, something like that, and engage in a club or some type of other group that you can explore that and build upon that. Because, you know, maybe it's something that you like and you decide that you can whittle art and you sell that. That's additional money on the side that you can have.
Yeah.
So that's, I think, all that I am seeing right here. Mr. Schmidt, am I missing something?
I have two questions. One, is it the court's intention for the ERP that Mr. Alden is not eligible to start program till a year and a half, or not eligible till release in a year and a half?
Not eligible to start from a year and a half of in custody in prison.
That, I think that kind of answers what my second question was going to be. Is it the court's intention to count the 366 days credit for the year and a half?
No.
Okay, that's all.
Mr. White.
That clarifies everything, Judge.
All right. Mr. Alden, I know that this sucks for you today. I know it does. I want to say I'm sorry that you're in this situation. You put yourself in this situation. I really, truly hope you learn from this and that you improve your life and that you're going to be able to be here with your mom. Okay? So good luck to you. I hope you all the best.
Thank you.